Good afternoon, Ms. Mfenyana. Please switch on the mic. How are you this afternoon?
I'm well, thank you, Chief Justice. How are you?
I'm all right, thank you. I've greeted you on behalf of all the commissioners, and when I asked you how are you, I was doing so on behalf of all of them. So nobody will ask you how are you.
Thank you. I hope the commissioners are well as well.
Let me thank you for availing yourself for consideration for appointment as a judge of the Eastern Cape Division. I'm going to ask you certain questions, whereafter I will allow the judge president to put his questions to you, and thereafter the premier, and thereafter any other commissioners who might wish to put questions to you. You possess, as I see it here, 3 degrees, B.Juris, LLB, and LLM, is that right?
That is correct, Chief Justice.
When did you get them, and from which universities?
The B.Juris and the LLB I got from the University of Durban-Westville. That should have been 1993.
Please speak up a bit. Maybe bring the mic closer if necessary.
Is that better, Chief Justice?
Yeah, I think raise your voice a little bit. Yeah.
Oh, okay. The B.Juris and the LLB I got from the University of Durban-Westville.
Yes.
And that should have been in 1993 and 1996, I think. I'll just have to refresh my memory. It was many moons ago.
Oh. I thought when you got your degrees, it's like when you got married, you would not forget.
1993.
But anyway,
1996, and then the LLM from the University of Pretoria. It was in 2007.
Yes. And which year were you admitted as an attorney?
In 1998.
And you have been practicing as an attorney for about what, 14 of the years that since you were admitted?
That is correct. This would be my 15th, though, Chief Justice.
The other years when you were not practicing as an attorney, were you in the corporate private sector?
I have the parastatals. I was with the Law Society, which is now called the LPC.
Yeah.
I was with the Human Rights Commission.
Yes.
And I was in intelligence as well.
Yes. So when exactly did you start practicing as an attorney?
So I started immediately after my admission in 1998. And then I practiced for about a year until I took up a position with the Human Rights Commission. And I was then out of practice until 2009, when I then started a practice.
You went back to practice?
I went back to practice, yes, that's correct, Chief Justice.
And you have been practicing since then, and you continue to practice?
I've been practicing continuously since then.
Yes. And your practice, what are the main branches of law that your practice deals with?
It's mainly commercial work, but it's a blend of areas. Contractual work, we do opinions for our corporate clients, interpretation of contracts, and all the work that would be involved in a contract, up to even litigation. So litigation as well, civil and commercial, is one of our biggest practices. We do do get, a few aviation matters from one of my clients, because I do have a qualification in aviation law, energy. Used to do some work from the energy regulator, and we do also forensic investigations and collections. And
When you say connections, what do you mean?
collections.
Oh, collections.
Yeah, debt collections.
Okay,
Yes.
all right.
And there's a bit and growing work in administrative law, purely out of passion, really. It is a field of law that I'm not that knowledgeable in, but that interests me quite a bit.
Yes. Do you do trials yourself as such, or do you brief counsel when there are trials?
It's a combination of both. I mean, court work is something that I enjoyed for some time, but I must say that when I started acting, I had to phase that out a little bit, because it becomes very difficult to sustain a litigation matter if you are not going to be there, because when you get a date allocated, it's very difficult to get dates, especially in Gauteng. And once you've got a date, it's like gold. So you have to be available. You have to make sure that you're available on the date that the trial is set down for. So the short answer is that yes, I do trials myself.
Yes, and is that both in the Match Court and in the High Court?
Both, Chief
Both.
Justice.
Yes. So in some cases you brief counsel, in other cases you do the trials yourself.
Indeed.
Okay, all right. And does your practice have a lot of motion court work?
Yes, that's predominantly the court that I have appeared in the most over the years.
And your motion work would involve what types of cases? Liquidations, matrimonial matters, other matters, or what types of matters would fall under your motion court in your practice?
We're a combination of matters, matrimonial matters like Rule 43s, summary judgment applications, I think other interlocutory applications that you could think of, exceptions, any interlocutory application that could be involved in the course of a trial.
And you said you have acted as well, is that correct?
I have indeed acted, Chief
In
Justice.
the High Court?
Yes, Chief Justice.
Okay. Are you able to indicate for what period you have acted? And when I say for what period, I'm looking at the aggregate terms or months that you have acted. If you put all of them together, even if they are not sequential.
I think the last time I counted, I was at 38 weeks.
38 weeks.
Yes, Chief Justice, I have since acted for another 10 weeks. So I would measure it at about 48 weeks to date.
Oh, okay. Excuse me. And when you have acted in the High Court, have you done trials as well as motion court?
Yes, I have.
Do you have a recollection maybe of about how many judgments you have handed down during the 38 weeks, more or less?
I think in the 48 weeks, I think I can calculate it to the 48 weeks. I have counted a total of 71 judgments that I was involved in. But of the 71, I scribed 64.
I'm sorry, you what, 54?
I wrote
54.
64.
64, yes.
Yes. So the other 7, I was part of the panel, but I was not the scribe on 7 of those 71.
Okay. So you have been able to write at least 64 judgments during your acting stints, different acting stints.
Yes, Chief Justice.
Yes. And the branches of law covered by the judgments that you have written, are you able to indicate what branches of law, roughly speaking, they cover?
They varied from criminal matters, civil matters involved insolvency matters, matters relating to trust law, and your usual procedural issues that would ordinarily come before courts, like your exceptions. I think if I look at the grid, I would be able to look at a matter and be able to know what it was about. If
I
you would allow
don't
me.
need you to be exact. I just wanted you to give the commissioners just an idea,
Broad idea.
even if it's not precise.
Matrimonial matters as well. The way matters involving immigration law, the way administrative reviews, the way commercial matters involving, I think I had one tax law matter, and I did attract, I think about 2 matters involving construction work, and yes, and,
Yeah.
and I think energy law as well.
Yes.
Yes.
How have you found presiding in trials in the High Court?
Look, it's a daunting task, Chief Justice. It's something very different from being in practice. For starters, you have to switch your mind from being involved in the matter. You're not one of the litigants, because naturally, as a practitioner, when you are faced with a matter, you can already see where this matter should go. But when you sit as a judge, that is not your task. In fact, I think I dare say that you should try and avoid making a decision before you've had the matter fully ventilated before you. So that was the first challenge for me, that I had to switch and listen and read the papers and make perhaps a prima facie view before my view is settled, because your prima facie view changes a couple of times during the course of the hearing of the matter. So that is one aspect I would like to mention. The other issue is the learning that you get from presiding over matters. It's priceless. It doesn't come easy. It comes at a cost of changed sleeping patterns, if any. It comes at a cost of what people call not having a life. I don't quite know what that means, but your work is your life. You read, you write. You read, you write. That includes the research as well. That is your life.
Yes.
Yes.
And have you sat in full bench appeals during your acting stints?
I have sat in very few.
Yes.
But I have.
Yes. Are you able to share with the commissioners under what circumstances, if you are sitting on appeal, you would interfere with factual findings made by the lower court?
It's, I think to sum it up, I would say if there's a clear misdirection. Otherwise, I think it goes without saying that as an appeal court, you are not privy to the witnesses. The witnesses are not before you. You simply adjudicating the matter on the record, and you do not have the advantage or the privilege of seeing the witnesses and making factual findings about this and that, about the witnesses, about their demeanor, and all related matters. So unless there is a clear misdirection that would lead to a conclusion that no court should have or could have reached the decision that the lower court did, then you may, in those instances, interfere in that decision.
And if you are sitting on appeal and what's before you that is being appealed against is a decision taken in the exercise of a discretion by a lower court, under what circumstances could you interfere with the exercise of the discretion?
I think once again, the issue of a misdirection is a catch-all. But I would say that in addition, where there's been an exercise of a discretion, if the discretion has not been exercised judicially, which in itself is a misdirection, then you may interfere as the Court of Appeal.
I will now allow the Judge President to ask you questions. Judge President.
Thank you, Chief Justice. For the sake of completeness, good afternoon, Ms. Mfenyana.
Good afternoon, JP.
For record purposes, you sat together with me and Judge Skuman in a full court matter, which is a reported judgment on socio-economic rights.
That
Education.
is correct. That's correct, yes, yes.
Center for Child Law versus Minister of Basic Education.
Yes, that is so.
Yes. And in that matter, the full court sat as a court of first instance, isn't it? Mm-hmm. What is the difference when a full court sits as a court of first instance and when a full court sits as a court of appeal? Is there any difference when it comes to taking the matter on appeal further?
I hope I'm understanding the question
Maybe let me
correctly.
simplify it. Do you need the leave of the full court when it sits as a court of appeal? It sits as a court of appeal, the full
Yes.
court, and it decides in a particular way, and somebody is thereby aggrieved, and they want to take the matter up with the SCA.
I'm saying, Judge President, I would assume that in that case, litigants would then have to petition the Supreme Court of Appeal, which would be the next level. It sort of seems to be the logical, thing to do for me, as opposed to when you were the court of evidence, in which case you would have to seek the leave to appeal from, that court of first instance first.
The full court itself.
The full court itself.
Yes, thank you. And then on the questionnaire, you mentioned that your litigation proportion when it comes to criminal law is 0%, and then when it comes to constitutional law is 0%, according to the questionnaire. Remember?
According to the reality
Yes,
as well.
Come again.
According to reality as well.
All right. Anyway, would you say your acting stints have served to equip you in those areas where you've been lacking experience in?
Greatly.
Yes. And then 11 of your judgments attracted applications for leave to appeal, you remember?
Yes, I do.
Yes. 6 of those have been confirmed on appeal. You confirm that?
Yes, I do.
And
confirm.
3 were overturned on appeal, and 2 have yet to be heard by the full court and the SCA respectively. You also confirm that.
I would confirm that, JP, and I think to my advantage for the time being, I must say, I must add that of the 3 that were overturned on appeal, there is one that has attracted a further appeal. In other words, my application for leave to appeal was, my judgment was overturned, but the losing party on appeal is now challenging the decision of the appeal court. So I think the jury is still out on that.
Yes. Which one is that, Ms. Mfenyana?
Let me just.
If you
check
can
that.
remember offhand, I wouldn't love to
I have
detain you on
noted
that.
it. I have noted it. I think that is that matter of. It's not Malabo. 1, 2, 3. I think it's the matter of. Yeah, it's the matter of Nondonga. Nondonga versus MEC for.
Please
for
pull the
health.
mic closer to you. Your
I
voice is very
apologize.
soft.
I
So we
apologize.
need to hear you.
I apologize. The matter of Nondonga versus MEC for Health is the last one on the grid
Yes.
that was sent to me.
No, the SCA there, if I may help you, dismissed the application for leave to appeal with costs on the grounds that there was no reasonable prospects of success. So in other words, the full court's judgment still stands.
Okay.
Yes. Anyway,
All right.
in its commentary, the GCB has referred to, among others, Veichile versus MEC for Health, a judgment that makes mention of case flow management. Now, here is my question. In your view, is judicial case flow management beneficial to our civil procedure system?
It is.
How so?
Over the years, I think we all know that the country has become quite litigious.
Yes.
The courts are flooded with matters, and the finalization rate of the matters is being affected day by day. Now, case flow management, contrary to some belief, is not a matter where judges necessarily get involved in the merits of the matter, but the necessity of directing the litigation and keeping a view on a matter as a judicial officer. I think it's something that can't be, overstated, because it gives a judge the opportunity to direct the proceedings. Look, as a practitioner, I know there are very many factors at play in the course of litigation. A matter may be delayed because, parties are trying to sort something out. In the meantime, the court roll is clocked. that matter has perhaps been set down, it's been allocated a trial date. Other matters can't, get through. And on the doorstep of the court, on the day of the hearing of the matter, one or other issue is outstanding, and the matter, cannot be heard. So I think case flow management then is useful. I would like to believe in all matters as a matter of fact, not only, just, I think there's a case to be made for its introduction in other areas of the law.
Yes. And would you say the Gqeberha matter upholds case flow management, or it simply says it's not necessary? If you've not read the judgment, you may say so, because you penned it a long time ago. I'm just harping on it because it happens to be a judgment referred to by the GCB.
Judge President, I want to make sure that I understand you correctly here. When you say, do I think that the Gqeberha matter upholds case flow management, you mean my judgment
Your
in
judgment
that matter?
in Gqeberha, yes.
My response to that is not going to be very direct for this reason. The Gqeberha matter in itself and that judgment was not per se on case flow management.
Well,
The
there'll
judgment-
there will never be, sorry to interrupt so that I help you. I'm not envisaging a situation where there will necessarily be a judgment dealing with or enunciating a principle about case flow management. All I'm checking with you is whether on reflection, the Gqeberha judgment upholds or doesn't uphold case flow management. That's all I want to know.
Mm-hmm. Excuse me. I think to the extent that there was an opportunity that was missed by the parties during the case flow management conference, that it didn't uphold it there. However, I think I would like to add that I think for the benefit of the commissioners, what had happened is that the matter had served before me on a condonation application for ILPACOSA, what is it, an institution of legal proceedings against state organs. And the matter had appeared before a colleague, and it was unopposed, and the matter was referred back to case flow management without that court dealing with the issue, with the condonation application. So it went to case flow management, and the parties were then summoned or directed to appear at a case flow management conference before a different judge. So the judge at the case flow management hearing, seeing that the parties are not settling, they just were, worlds apart, referred the matter back to motion court, and that's when it appeared before me. So at that stage, at case flow management, then that opportunity to perhaps bring the parties closer together was indeed missed.
Yes. And then lastly, which of the judgments you penned demonstrates exposure on your part in commercial work?
I would...
Can you think of any one of the judgments listed?
I think I think there's a few. I just don't remember the names, but I just remember the issues in the matters, JP. I think I won't waste your time. I'll just go quickly through them. I think the SARS matter, the total human resources versus the Commissioner of SARS, that did. I think Arsenio versus Berry Dust, because that was also a commercial matter. I think Tiacher versus Koken, that also was a matter which I think it was the insolvency, like a disposition without value matter. I think Herting versus Summermania also did. Price versus Chantilly Trading did that as well. And.
And so on.
Yes, JP.
Could you please indulge me, CJ, one last question?
All right.
Since being interviewed last year, you've acted in the Gauteng High Court, Pretoria.
Yes, JP, I have.
And did that acting stint serve to hone your skills further?
It did.
Yes.
It certainly did.
Thank you, CJ.
Thank you, JP. Premier.
Thank you very much, Chief Justice, and good afternoon to commissioners, and good afternoon to Ms. Mfenyana.
Good afternoon, Premier.
Thank you very much. Don't have much, but I just wanted to check from where you are, is there any area of law in which you regard yourself as requiring further exposure? If any, can you specify? That will be the
yes.
first question.
Yes, oh yes. There's always opportunity for learning. I am still at baby level. Criminal matters, I've sort of become comfortable in criminal matters. But I think I still need further exposure. I would like further exposure in criminal matters, both criminal trials and criminal appeals. There are matters which, although they form part of the civil litigation sphere, I would like more exposure to, that being medical negligence matters. Because I think, and I think road accident fund matters alike. These being matters that I did not practice in, or I do not practice in to date in my practice. So I would like to have more exposure to those matters as well.
Thank you, CJ. Once again, do you regard yourself as an activist or a conservative in the sector where you are, one, but also in the Eastern Cape, not necessarily in the Eastern Cape, I think just in the country. There's a currently ongoing rationalizations of judicial areas, etc. Do you think this is a process that has taken so long? Is it long overdue from where you are?
But Premier, I would also like to make sure that I understood the question with regards to activism. You mean activism as an individual or as a judge? From a judicial point of view, rather. Okay. I think from a legal point of view, as a professional, I do regard myself as an activist in my sphere of work as an attorney. Why do I say that? I have a vested interest in the development of younger particularly female lawyers. And although I have not done enough, because I believe in working maybe one or two young lawyers, young female lawyers at a time, and then it carries on and on and on and on. So that is as far as I have been active in that sphere. But as a judge, I do not regard myself as as a judge that subscribes to judicial activism. And the reason for that for me is simple, that the judiciary itself, I mean, in our country, if you look at the rules that govern and the code of conduct of judges, it has not been developed enough yet to allow judges to be so involved, so actively involved. And also, it would encroach on the other arms of government if it goes unattended or unmonitored. So as a judge, and an acting judge at that, I think it would be very daring of me to just dive into, this environment that I am put in, that I'm being tested in, and I, change everything contrary to what the laws of the country say. So no, I am not an activist as a judge.
The other part of the rationalization?
May I ask the Premier to repeat the last part of the question?
The current ongoing, the rationalization of our judicial areas. Case in point, where I'm seated, I'm just thinking about what's going on in the Eastern Cape, where someone in King Williamstown can only apply in Grahamstown whilst there's a 5-kilometer high court just adjacent to that person because of the old order system.
Yes, and you...
your view, I just wanted to get your view.
It's a very unfortunate situation, and I think the reason for it is historic. And unfortunate on the basis that the Eastern Cape is predominantly rural. And it being rural, we know what goes with the rural population, that people are indigent in those areas. And the expectation that, for example, a litigant in, let me say, Berkeley East, where I was born, has to travel all the way to Grahamstown to be heard. It's unfortunate, and I understand that there may have been reasons for it at the time, but I would like to believe that we have evolved. The law has got a need, and the judiciary as well has got a need to evolve with the evolution that has taken, place post-democracy. So I do believe that there is a case to be made for that.
Ngosi, CJ.
Thank you, Premier. Commissioner Nochesi.
Thank you, CJ. The CJ greeted you on my behalf as well. So,
Yes, Mr. Jesse.
look, I was part of your interview on the last occasion, and I was happy. I just have had an interest on these cases, the one that we've just discussed with the JP, for instance, because it is listed here. by the GCP as one of those cases, as one of your cases. This is Vechile versus MEC for Health.
Yes, sir.
I'm sorry, before you answer, Ms. Mfenyana, I just want to tell commissioners we have gone beyond 35 minutes. So just be aware of time.
Thank you.
Continue and then you can answer the question.
Thank you. No, I will try. I have a few questions. Too. Now, my question relates to that judgment. It seems to me that the judgment involves a declaration that the plaintiff's claim, one, is not prescribed, two, the plaintiff seeking condonation for the late institution. And when I read the judgment, you granted the order declaring prescription, and that the matter is not prescribed purely on the papers, that is on the motion proceedings, in circumstances where there was a dispute of fact, because the defendant is saying the matter is prescribed, plaintiff is saying it is not prescribed. There's a dispute, but you decided to grant that order, one. Secondly, you made no separation, because we have to separate the issue of prescription, as it requires a factual inquiry. Can you reflect on that judgment?
Yes, listening to you now, Mr. Nkesi, I'm thinking on my feet that the declaration of whether the matter had prescribed indeed was a matter that was contested by was it the respondent?
Just 1 second, Ms. Mfenyana. Can everyone hear the candidate, please? It's in your interest that they should all hear you. So speak aloud. They must hear you.
Yeah.
Chief, through you, Chief Justice, perhaps it might help if you could ask the candidate to speak directly to the microphone.
Yes.
Not keep on
Yeah.
looking at
the people who are asking me
Yes.
in
questions.
the direction from
Yes.
which the question came. Yes.
And also understand it's not a conversation between you and whoever is asking the question. You are addressing all of us. Yeah. Okay, please continue.
What I was saying, Chief Justice, very briefly, I think that Mr. Nkesi's question has caused me to reflect on the judgment. And for starters, the issue of the prescription, which I did not mention when I was responding to the judge president, is a matter indeed that came before me in circumstances where the respondent had contested the issue of prescription. In fact, they had alleged that the matter had prescribed. So the matter, that aspect was in dispute. However, the defendant, and I'm still thinking on my feet, and the respondent did not oppose the matter and was not, so when the matter appeared before me, the respondent was not in attendance. So it was basically uncontested. But if I fast forward to the question, I think then, in hindsight, it would have been one of those matters where I would perhaps have had to employ the famous Plaskon-Evans rule in the determination of that particular aspect of the matter.
No, perhaps maybe we don't understand each other.
Mm-hmm.
Let me try and explain. Pleadings have been filed in this matter. Summons, they pleaded. In their plea, they plead prescription of the matter.
Yes.
But because there was this issue of the condonation for the institution of proceedings. They bring the motion proceedings before you.
Yes.
The question is, was it competent? I mean, let me be direct. Was it competent to grant a declarator that the matter is not prescribed in instances where first, there's no separation of issues. Secondly, this is a trial issue, the issue of prescription. Was it competent to grant that order? I must explain that I'm not reviewing that judgment, but I'm just checking on procedures.
Yes.
Because there are rules here, you know, that must be followed. So when you reflect and look into this, was it competent to grant that order first without making an order of separation, which would, in these circumstances, have been on a notice to the defendant?
Indeed. I think, Mr. Nokesi, whether you intend to or not, I think you have probably made out a case for one to reflect and concede that in hindsight, perhaps there should have been a separation. I will add to that I think the fact that the respondent did not oppose the matter was perhaps a factor that played a part in the decision that was made ultimately.
My last question on this. I find it extremely difficult to understand when you say, because the matter is not opposed, therefore that takes away the duties of the presiding judge. Is it not that the order itself is finally the order of the court? Doesn't matter if the matter is opposed or not opposed. Is it not that it is the duty of the presiding officer to ensure that the rules, the law, there's compliance, complete compliance? So that my worry is when you say one of the things that influenced your decision is simply because it was not opposed. I would accept if you simply say, well, on a reflection, this was simply a mistake. But to take it further and say it is because it was not opposed, that's where my problem is.
No, Mr. Nokesi, my answer to that question was the fact that it was not opposed may have played a role in the decision that was made, in the oversight.
Thank you, CJ.
Thank you. Commissioner Matolo Sepu.
Thank you, CJ. I have to declare that I know Ms. Mfenyana. She's part of the South African Women Lawyers Association and very active. I'm not sure why you are so slow, or are you afraid today? I know you to be very, very active. Or maybe because you are sitting next to the Premier, I don't know. But she is a very active, she's an activist, by the way. And you should have stated that you are not a mere one trainer. You train a lot of women, especially in fields like energy and all those, like civil aviation, you do that. I think that's, you must talk and say, this is what I do. But what I wanted to find out, since you have been you appeared the last time here, and now, how do you think you have improved? Not to say the last time you're not bad, but how do you think you have learned from the last appearance up to now?
I think that I have certainly gained much more exposure. I wouldn't say in different aspects of the law, but I think in the adjudication process itself, having acted back in the Eastern Cape and in Gauteng, which is a totally different kettle of fish altogether, I must say. I have lost more sleep than before. And that, as difficult as one may say that is, it goes to building, the character and the determination or the necessary skills that are needed for a judge. So it was a boiling pot, which I sort of not necessarily sailed through, but managed to pull through. So that is something that I think I take away from that experience, from the time that I was here, the last time in October.
Thank you, CJ.
Thank you. Commissioner Totovu.
Thank you very much, CJ. Good afternoon, ma'am.
Good afternoon, Commissioner.
Are you okay?
Hiya, I am okay.
Okay. I learned that you have an interest in commercial law. But before I traverse my question, I want to ask you a key question. Do you know the Zondo Commission of Inquiry?
Yes, I do know the Zondo Commission of Inquiry.
Yes, as I understand, it's a commission that deals with or investigates allegations on corruption, state capture, and all of that. And one of the key issues that is emerging out of the commission is the fact that there are violations in terms of Section 217 of the Constitution. It deals with tendering processes that when the state procures services and goods, it must be fair, equitable. I'm sure you are familiar with that.
Yes, to some extent, Commissioner, I am.
Yes. Now, it is quite clear that there are these violations that are perpetuated. In your view, are there any defects that you can identify in relation to that provision of the Constitution, the 217?
Chair, with your permission, before she responds, I think perhaps you should check the extent to which the question in itself is relevant to our own criteria, unless if it is in terms, because if it is in terms of the general knowledge of the law, but you then refer to a specific section, it has to be somehow relevant to the criteria.
No, I will allow it. I'm watching. I want to hear the answer. I think there was a reference to a judgment, if I'm not mistaken, that related to tenders that the candidate dealt with.
I was going to
Yeah.
exactly say that.
Yeah.
Yes. My question, if I want me to repeat it, is to determine whether Section 217 of the Constitution as it stands, do you think that it has some defects that needs to be repaired or not?
The Section 217 is the section of the Constitution that deals with the procurement of goods, the transparency and the equitability and fairness. Is that the one? I don't know off the cuff, unless you want to clarify the question, even further. Commissioner, I'm
Yes.
not sure. I'm not sure.
I'll do that
of-
for your sake.
Yes.
I'm saying I'm asking this question because what becomes apparent, especially in respect of commercial law, your area of interest, is that there are so many problems with regard to whether you say state capture, whether you say corruption, whether you say fraud in our country. And that provision of the Constitution tries to regulate how the state must procure goods and services. Now, the fact of the matter is all of these things happen perpetually and they need to be arrested in one way or the other. Now, I just want to test your view in relation to whether do we need some improvements in that respect or not.
Allow me to respond to the question not necessarily in respect of the Zondo Commission of Inquiry, but in respect of the procurement.
No, it's okay,
of,
yes, okay.
of the procurement of goods as allowed in terms of that section, Commissioner. I think there is room for improvement. However, in my practice and experience, having dealt with procurement investigations, I am not certain that I am convinced that the issue is with the section itself, more than it is with the application and perhaps some, opportunism, or corruption, as it were, that parties would get involved in when it comes to issues of procurement. I may mention one aspect. For example, there's a clause that seems to appear in all bids that you do, that says let's say company X reserves the right to cancel the bid at its own discretion at any time for whatever reason. And bidders are required to say yes to that, and they do, because if they don't, then the bid is going to be then they're going to be kicked out. So that, for me, on its own, before you even go to how the goods are procured, is a gap for me. It is a problematic area that could cause problems in the procurement of goods or services. So to answer your question in relation to improvements being made, yes, there is a wide scope for improvement. I'm just not certain that I'm able to put my head on the block and say that it requires a constitutional amendment.
Okay. No, it's okay. No, it's okay. That response. Let me get to the second question, with your indulgence. CJ, as a woman who wants to ascend to the bench, what are those challenges, practical challenges, that you think women of your caliber confront as part of the transformation of the judiciary?
I think one that stares me directly in the face is an assumption that women are generally incapable and that they come second to men. Why am I saying this? I'm saying this because with all the good intentions that are there to develop women, trainings being provided and the like, I think we need to be careful that the starting point that we emanate from as a country is not a starting point that says, because you are a woman, therefore you need assistance. Assistance is always welcome, but the undertone that as a woman you are incapable sort of pushes women to a special category of the community, which is not necessarily the case. So you find yourself having to perpetually measure up to men, whereas the judiciary, or any job for that matter, is not a man's job. It is a job of a person who is capable, who is willing, who is teachable, who has the energy, the zeal, and the willingness to perform that function, whether man or woman. So that is the first challenge that I think women face. The second challenge, I think, would be women ascending to the bench. I've mentioned sleepless nights and sometimes no sleep at all, and that is not an exaggeration. And I assume that women with small children would find the bench unattractive. And I would like to dare say that if there were to be any kind of assistance, assistance provided to women because they are women, it needs to be on those aspects that make them different from men. That of caregiving and nurturing being one. So those are just a few of the challenges that I think women face.
All right, thank you, CJ.
Thank you. I'm going to go to Commissioner Mapisa-Ngula, and after that to the commissioners on the online, and it looks like there might be one more question after that. Commissioner Mapisa-Ngula.
Thank you very much. Thank you, CJ. Thank you, Judge Mfenyana, for availing yourself. Mine is just one quick question, and that is, in your own words, what would be the importance of judicial independence to you, in view of the fact that you come from another, okay, you have your practice, but before then, you've served in the other arm of the state, and a critical one for that matter. You get my point, no?
Yes, I believe I get your question, Commissioner. Commissioner, to me, independence as a judge is the most important aspect. There are many others, but I rank it quite high. For the very same reasons that you have mentioned, we come from different walks of life. And in all these walks of life, we work with people. It is expected that during the course of your performance of your judicial functions, a matter may come before you that you may not necessarily, having declared, because the declaration for me is the first thing that you need to do. You need to declare whatever interest or relationship you have in the matter. I'm sorry, not interest, because I think as a judge you shouldn't have any interest in any matter. But if you should declare whatever relationship you may have. But that does not mean that because you've worked with with all these people that are appearing before you, that you have to recuse yourself in all matters. You will take each case, on its own merit. I may mention, for example, that something that's not related to the arm of the state that you mentioned that I worked for. In my practice, I represent, certain clients. So a corporate client appears, a matter appears before me in the Eastern Cape, and the entity is a client that I had represented on a different matter. Naturally, I had to inform my judge president that this is the situation, and take it from the parties. And then the recusal application is something that would follow. It's not automatic as well, but you need to put the parties at ease. You need to be upfront about it. So judicial independence is very important, but that does not mean that you are not, you're going to be recusing yourself in all matters, and then that's unfair to your colleagues because as practitioners, we work with people.
Thank you very much.
Thank you, Commissioner.
Thank you, Commissioner. Ms. Mfenyana, may I ask you to try to shorten your answers, please? Sometimes they are quite long. I know it can be difficult, but try. Can I go to commissioners who are attending virtually? Is there any commissioner who has a question?
Commissioner Barnard.
Yes, Commissioner Barnard, go ahead.
Thank you. Ms. Mfenyana, afternoon. I just want to speak to you about the drafting eloquence matter or just clarity of drafting, let's call it that. So the first question is in this relation is when there's parties to an agreement, what is the situation when one party is in breach? Let me put it to you, I put it to you that the other party basically then gives notice or demand for the cancellation for compliance, and if it's not complied with, then has the right to cancel. So my question to you in that situation is who cancels the agreement? Is it the party or the court that cancels the agreement?
I'm not sure if I'm understanding the question, Mr. Barnard. Are you asking if parties enter into an agreement and
I think the question is whether when one party to an agreement has acted in breach of the agreement, who cancels the agreement when there's been a notice of compliance but still no compliance? Is it the court that cancels the agreement or one of the parties? I understood it to be that to be the question, Commissioner Barnard. Am I right?
That's correct.
Yes.
Chief Justice.
well, if I'm understanding the question correctly, the other parties appearing the court before the court to request cancellation of the agreement. So that party would be the party that would be requesting the cancellation of the agreement, and then the court can either grant that agreement. If the court has granted that agreement has been cancelled by an order of court at the instance of the party that was seeking that order.
So if we can look at your at the bundle at the judgment of the Office of the Premier and the Director General of the Office of the Premier versus the South African Youth Council. So that would be on page 43 of the bundle. And one then goes to, do you have it?
I do, Commissioner.
All right, thanks. So if one then goes to clause 11 of the agreement, so I'll just read the extract that's relevant for me. As the respondent continued to be at war with itself, the applicant on 29 September 2017 served a notice of cancellation in accordance with clause 16 of the agreement. So my question is, was this a notice to cancel the agreement? Or was it a demand for compliance where after cancellation would follow?
Commissioner Barnard, you've referred me to page 43, which is where the judgment starts. Where were you reading from?
Sorry, I'm so sorry. It's paragraph 11, and specifically that's on page 46, although the numbering is a little bit unclear on that page. It's page 46, paragraph 11.
Yes, Commissioner Barnard, I've read that paragraph, yes.
So the question is that a notice of cancellation, or is it a notice of, or is it a demand to comply, failing which cancellation would follow?
They had served a notice of cancellation.
So that the agreement had in fact been cancelled?
No, they were notifying them of the intention to cancel the agreement. In
Okay.
terms of
So-
the,
so- Sorry, I didn't mean to interrupt.
yes, in terms of the agreement that they had entered into.
So this is, one would call this then the demand. Now, my question is wouldn't it then be more, give more clarity to the reader if you had drafted and said the notice of intended cancellation or a notice of demand to cancel or something to that effect? Because it is confusing to the reader. This seems like it's a notice that the agreement was already cancelled.
I think it will boil down to legal terminology then, because I am not aware of a notice of a demand to cancel, but a notice of cancellation is a notice of cancellation, but it would still need to be confirmed by the court, which is why the parties were before the court to seek an order that agreement be cancelled.
Were they not seeking a declaration that the agreement had validly been cancelled instead of the court cancelling the agreement?
I would have to refer back to the judgment, Commission, about it. I just don't see the end. It would appear to me that they were seeking cancellation of the agreement, which is the order that was then ultimately granted by the court on page 51.
See, if one looks on and I agree with that, but if one looks at paragraph 20, then the clause.
Commissioner Barnett, you do
Yes.
realize it's been more than 2 questions. Just finalize, please.
Thank you. Well, I'll put it to you then that in terms of clause 6, paragraph 20, which quotes clause 16, it's a standard breach of contract clause, and basically there should have been some other notice to or demand to cancel, and then a further notice that the agreement in fact had been cancelled. I don't think it's the clarity of the order seems to be that the court was stepping in and cancelling this agreement, whereas it seems like there should have been a declaration that the agreement had been validly cancelled. But I'll leave it at that, and then you can perhaps respond to that. Thank you, Chief Justice.
Thank you. Did you want to say anything in response to that, Ms. Mfenyana, or not really?
No, Chief Justice.
Okay, all right. Commissioners are attending virtually. Is there anyone else who had a question?
Thank you, CJ.
Yes.
Okay, I don't have a question for Ms. Mfenyana, but I just want to declare that I know her. She's one of our leaders. And I also commend you, Ms. Mfenyana, for what you are doing for young women legal practitioners. We need more women like yourself who can take young women under their wings and mentor them, so we can accelerate the gender equality in the legal profession as well as in the judiciary. Thanks, CJ. Thanks, Ms. Mfenyana.
Thank you.
Thank you.
Thank you, Commissioner. Is that all from the commissioners attending virtually, or is there somebody else?
I have no questions. Thank you, Chief Justice.
Thank you, Commissioner Breitenbach. Commissioner Malema, are you fine? You have no questions? Okay, he is not there. Commissioner Baloyi, did you have your hand up at some stage? Okay, all right. I think you are the last one.
I did. Thank you, Chief Justice. Good afternoon, Ms. Mfenyana.
Good afternoon, Commissioner.
You said that you acted for 48 weeks, a total of 48 weeks. Is that correct?
Yes, Commissioner.
And of that 48 weeks, how long of it was, maybe let me ask the question. In that 48 weeks, did you spend time in an opposed motion?
Unopposed?
Yes.
Yes, I did.
And do you remember offhand how long you would have spent in an opposed motion?
A total of 24 weeks.
Okay. In that 24 weeks, or coming out of that 24 weeks, what are your lessons in conducting unopposed motion court that you would list as the lessons that you learned?
I think the first is that before you deal with a matter, you need to ensure that you have read your papers. The reason for that is simply that when parties appear before you and they argue their matter, your view may go, in different ways. And the other lesson is that the parties are before the court to assist the court, so you have a duty to listen to the parties and hear the parties out. And what I also consider to be quite relevant is to engage the parties to some extent with the view to understanding whatever bottlenecks there may be or what the issues are about, so that in writing your judgment, you are not left with gaps.
Yes. You see, the reason that I'm asking the question is because of the discussion that you had with Mr. Nojesi. When he raised with you your decision on prescription, that you made a decision on prescription. And I am concerned when your answer is, well, the error crept in because there was no opposition, when you say that. Now, talking about my own experience, in fact, is that at the beginning of pupillage, or right at the beginning of your practice, you get told flippantly sometimes that there's nothing like an unopposed matter in court. Your opponent is the judge. When you're appearing without an opponent, in fact, your opponent is the judge, because the judge has read the papers through and through. The judge has looked up the law, has looked at what you are asking for, and the judge is going to debate with you and raise the difficult issues with you, which otherwise an opponent would have raised. Now, your answer to Mr. Nojesi suggests that there was a failing in this case, and I would have hoped that you would list among the things that you have learned in that 24 weeks, that in fact you have to be particularly careful when matters are unopposed, because attorneys and counsel will pass things through you. And I am concerned that that's not one of the things that you learned, especially in the light of your discussion with Mr. Nojesi. What do you say to that?
I think your analysis, and I think Mr. Nojesi's engagement are fair. That was an oversight. And I don't think I should be justifying anything about it. I would like to say this, though, that not having listed that as one of the things that I learned in opposed motions does not mean that it is not something that I consider. I mean, when you're sitting where I'm sitting, I mean, a lot of things creep in, nerves and all of that. But it is true, and it is something that I am acutely aware of, that especially in unopposed matters, you need to be extremely careful. And I would like to believe that I am extremely careful. But that matter that Mr. Nojesi brought to my attention is just one of those unfortunate matters where I think I committed an oversight.
Thank you. Chief Justice, I have only one other question.
Okay.
This arises from one of your judgments, and it's a judgment of Van Schalkwyk. You'll find it at page 24. It's paginated, page 24.
Yes, Commissioner.
Yes, I mean, you probably do remember this case, but from how I understand it, this is a civil claim, a claim for damages arising from an accident in which the driver was deceased, having driven because of instructions from the employer. Does that ring a bell? You remember that?
Yes, I think that the facts, I remember the judgment, yeah, the facts I vaguely remember, but I do recall this matter.
Yeah. Now, you summarize in the judgment that two special pleas were taken, basically being that the matter should not be before court because there's the COIDA, Compensation for Occupational Injuries and Diseases Act, Road Accident Fund. Those special pleas were taken and then pleaded over. And there's an application for absolution after evidence. You don't deal with the special pleas. The two special pleas. You instead go on to deal with the plea over, or the merits, in fact. You hear the case at the end, you grant absolution. Now, there are quite a few things that I would have loved to discuss, but I realize we don't have time. But at paragraph 13 of that judgment, you set out what you say an absolution from the instance engages. You say it follows from the above that the court in such an application, that is absolution, does not concern itself with the defendant's plea, but rather with whether the plaintiff has discharged the onus of showing the existence of a prima facie case. That's what you say at 13. But then at 24, you then say, no, not at 24, I do apply, at 14, in fact, at paragraph 14. Chief Justice, if you would just bear with me, I've lost my reference. In fact, it is paragraph 20. I do apologize for that. Under the heading causation, you then say, in view of my finding that there is no fault attributable to the defendant, and let me stop there. I'm struggling with how you've defined the test for absolution, and then here you now have concluded that the defendant is not at fault. You seem to have gone against what you set out as the test. Do you want to explain that?
I'm not sure if I'm understanding the question correctly, but you can stop me if I'm not answering you, Commissioner. My understanding is that both these paragraphs that you're referring to seem to highlight the fact that what the court confines itself in an instance where an absolution is sought is the plaintiff's case without, hearing the defendant's case. It seems to me that both these paragraphs would confirm that test. I'm not sure
So
where there is a discord.
That's why I'm asking. Do you want to explain what it means? Because on my reading of it, it seems like you made a finding on the liability of that the employer is not liable.
I hear you.
Okay. Thank you, CJ.
Does that mean you have no recollection, or does that mean you accept the commissioner's understanding that you made a finding that there was no fault?
Yes, I mean, if there is no other way to interpret paragraph 20, Chief Justice,
Yes.
because it seems to talk to the issue of fault,
Yes.
not being attributable to. I wonder if it doesn't refer to the plaintiff, but it says to the defendant. I mean, that's the judgment as it stands. But it would seem to me that, I mean, the case of the defendant had not even been heard. I mean, in an absolution matter. But that's the judgment as it stands.
What do you want to say to the commissioners about it? Are you saying it was correct to do it that way? Are you saying you realize it was a mistake to do that?
Ordinarily, you wouldn't make a factual findings, and this is what it seems that the judge, in the judgment, that is what I did. Having set the test for absolution, I then went to making a factual finding.
But are you able to explain how it came about, or are you not? Because I just want the commissioners to know whether this is a situation where you say, look, I realize I made a mistake, or you say, I can't explain, but I see it's a problem.
Okay, I can. I think if I remember now correctly, if you look at the judgment, the way it is crafted, that paragraph appears under the issue of causation. So the issue of causation was not dealt with at all, not even in the judgment. That is the only paragraph that would contain the issue of causation. That the matter having been, the court having accepted that absolution should have been granted on the basis that the plaintiff had not made out a case for the defendant to answer to. So I would like to believe that is what the judgment was referring to, that there was no a case for the defendant to answer on the basis of the case that had been presented by the plaintiff.
I think we've come to the end of the interview. Thank you very much, Ms. Mfenyana. I'll give you about 3 minutes if there are 2 or 3 points that you want to emphasize that the commissioners should take into account in addition to everything else when they consider your candidature. If they are, but you might be able, you might say you have said everything that needed to be said and you have nothing to add.
No, Chief Justice, there aren't.
Sorry?
There are not.
They are not, okay. Thank you very much. Once again, we thank you for availing yourself. You are now excused.
Thank you. Thank you very much.